All right, I'd like us to cross back to Homa Bay Law Courts just to continue listening to the court proceedings. Just to remind you that Michael Oyamo is appearing in court in connection with the death of Sharon Otieno. So let's cross over and listen in.
Mr. Impali, before the defense addresses me,
yes, sure.
What is the bulk of the work that is remaining? As regards the civilian for whom you've brought this application, what is it that is remaining for you to determine whether you really need to charge him?
Yes, we have.
Or whether you need to free him?
As I said, Your Honor, we have several devices, okay? Which I would believe that will bring a link between him and other people. That is number one. Two, we also need to analyze the call data in his phones and other phones that they think are related to this occurrence.
Analyzing call data?
Yes. Your Honor, we've also done postmortem and taken DNA samples, as I say, which are communications from the IO we will be able to get within 3 to 4 days. And Your Honor, also
results of DNA will be ready in 4 days?
In about 4 days. And Your Honor,
call data? How long do you need to look at the call data?
3 days, Your Honor. And also, Your Honor, they tell me that
how many gadgets do you have specifically that belong to the accused person?
There are very many, as I say. How many?
Belonging to the suspect that is before me.
Your Honor, the IOs tell me that 2 are personally his, but there are several gadgets that they think are linked. Yes.
So you only have two phones?
Yes.
Containing how many lines? How many
3.
SIM cards?
3.
Actually, what you are analyzing are the SIM cards.
That is why I had said, Your Honor, it would have been easier and better for the investigator probably to shed more light.
It is your application. You're not calling witnesses. This is your application. I don't want to put you on spot, and that's why I told you to get in a good brief from the people investigating. What is it that they are holding, and how much time do they need to go through, so that we look at the reality? You don't just tell me you're holding 10 sacks, gunny sacks of gadgets. I need to know how many are for these suspects, so that we know for real how much time do you need to look at 2 or 3 SIM cards.
Your Honor, we've made an application, and what our application is, we will need up to Monday. We were directed by the court directive. And what you're saying is this: the gadgets that they have, and we have experts with them here, they give an indication that in respect to DNA, they will need about 3 days. In respect to analysis of the devices that they believe are connected to the murder, will take about 4 days. Analysis of the data will take.
But all these things are being done by different experts. We have different experts looking at the DNA. We have different experts looking at the call data. And the information that you download from the providers, another different team is looking at it. So it's not like you'll want 3 days so that you're looking, all the experts are looking into the...
The reason why we're asking for money is very simple. After they do the analysis, they bring the file to us. We also have to make analysis and come up with a decision on whether the accused person is culpable or not. So we also need time. And we're willing to work over the weekend.
Yes, from the defense. Let's kindly switch off all our phones. Let's kindly switch off all our phones. We do not want the court to confiscate anybody's phone. Yes, from the defense, I think the prosecution is done. From the defense, we will have submissions, yes. Let's give them time. Just switch off the phones. Let's just give them time.
Thank you, Your Honor.
Switch off all the phones so that we can now proceed. Okay. Mr. Shoya, we will be having how many people submitting for the defense?
There's 3 of us.
So can we limit time?
We will try to be short, Your Honor.
Mr. Shoya, how long do you wish to take? So that we agree, so that you tell me you start from your stronghold.
We'll take 15 minutes each.
15 minutes is a lot of time. Mr. Shoya, I'll give you, who is the lead counsel there? If there's no lead counsel, I give everybody 5 minutes.
Your Honor.
Your Honor, we do appreciate that the court is constrained in time, but we must never lose sight that the liberty of a citizen is at stake.
I agree.
So if it is the liberty of the citizen, and these are rights according to him by the Constitution, kindly give us, be a bit more generous about it. Kindly.
I just want to limit you so that you know that you have time, we have time constraints, because we will not hear one matter today.
Yes.
We have to hear each and every other case that was scheduled for today, because this was not even a matter in the schedule for today. So let's have, now that is, you're already eating into time. So let's have Mr. Shoya. Mr. Shoya, you can stretch a bit, but don't go to 15 minutes. Yes. Start with your strong point so that when I say you stop, you just sit.
Yes.
Yes, Mr. Shoya, please.
Your Honor, I think before I respond to the application, I wish to express the displeasure of the defense in the manner in which the investigations are being conducted as against your court order that was given on 5th of September. Your Honor, paragraph 2.
Yes, go slow, please.
In contempt of the order given on 5th of September, paragraph 2 of that order, the court made it clear that the accused person should not be transferred, actually use the word shall not be transferred to any other place without an order of the court. Your Honor, on the 7th of September, that was Friday, we came to visit the accused at the station, but he was not in. The OB showed that he had been moved from the station at 6:30 a.m. for temporary leave out, which did not indicate where the suspect had been taken.
That was on 7th.
Yes, on 7th.
What time did you go to the station?
I went to the station at around 12.
And OB showed what?
that the suspect had left the station at about 6:30 a.m. in the morning. It did not indicate where the suspect had been taken. I personally talked to the DCIO over the phone, and he told me the suspect had been taken to Oyugis, where the postmortem was being done. You
talked to?
The DCIO over the phone, personally, and he told me the suspect had been taken to Oyugis, where the postmortem was being done, and that he believed we were aware of the same, and advised me to go there.
DCIO Homa Bay, that is?
Yes, Homa Bay police station. We sent one Lisa Wema, who is also in paragraph 6 of the order, who was allowed to see the accused person to see if she can access him at the hospital at Oyugis. Ms. Lisa Wema informed us that she was not at Oyugis at the hospital where the postmortem was being done. So we stayed at the station. Counsel Mr. Abisai joined me at about 2 p.m. and we were here up to 7:30 p.m. when the suspect was brought back to the police station.
At what time?
7:30 p.m. We were accorded very limited time to talk to him on the grounds that it was at night. And that was only 5 minutes. We were given only 5 minutes to talk to him on the grounds that it was at night, and the regulations say that we can only see him from 6 to 6. I was there on Saturday at the police station. We were there with Mr. Abisai.
The grounds for the regulations?
The police regulations are that they cannot allow visitors to see a suspect in the cells between 6 p.m. and 6 a.m. So we came back on Saturday, that is 8th of September, and the suspect told us he had been taken to Oyugis police station. He was locked up in the cell there.
On which day now?
On 8th, we came back and he told us that on the 7th,
On the 7th, okay.
he had been taken to Oyugis police station and locked in the police cell. The investigating officer, Mr. Hassan, visited him with some gentlemen who claimed to be medical practitioners from the government chemist and had come to collect DNA samples from him. The suspect objected to giving of those samples in the absence of his advocates. He says the IO informed him that he had an order of this court and the permission of this court to take him to a UBIS and to extract those orders
And to?
and to extract the samples from him. And that the court would inform his advocates of the same. I had occasion to talk to Mr. Hassan personally.
So was he sampled or not?
He was sampled. The DNA samples was actually taken. They extracted saliva from him in our absence and without our knowledge. Without our knowledge and without the procedures being known to us or even to the suspect. Your Honor, our concern, therefore, is that the accused person has been kept in police custody and the investigations are being conducted in a manner that is not transparent, and the conduct of the police have actually impeached the integrity of the process of investigations.
Just go slow on that again.
Yes, Your Honor, what I'm saying is that the conduct of the police has impeached the integrity of the process of investigations. The big question that is unanswered in this case, and we agree it's a matter of great public interest.
Yes.
The big question that is unanswered is why was the DNA being extracted on the same day the postmortem was being done behind the backs of counsel representing the accused person. Inasmuch as the complainant's family and the public at large have an interest in this matter, the accused person also has a right to the protection of the law under Article 27 of the Constitution, 27(1), of the Constitution, and the right to a fair trial. Your Honor, we submit that under Article 25 of the Constitution, 25C, subclause C, the right to a fair trial cannot be limited. It is a fundamental right and freedom that cannot be limited. And the conduct of the police while keeping in custody in disobedience of court orders limits the right of the accused person to a fair trial, which includes under Article 49 of the Constitution, (49C) of the Constitution, the right to communicate with an advocate and other persons whose assistance is necessary.
Right to communicate.
To communicate to an advocate and other persons whose assistance is necessary. Your Honor, this court ordered at paragraph 4 of that order that the accused person be allowed one phone call a day for at least 5 minutes.
Mr. Shara, 2 minutes.
On the same 7th of August, West Afro-Ugis, he was denied the right to even call his counsel and inform them of his whereabouts. So, Your Honor, in as much as the prosecution are seeking more time to conduct their investigations, they are also not coming before this court with clean hands. This is a cardinal principle of law, that you must have clean hands at all times. It is therefore our position that continual keeping of the accused suspect in custody violates his fundamental rights, particularly to the right of a fair trial. Your Honor, to address the application made by counsel before you,
Few seconds to go, Mr. Chair.
the affidavit they are relying on is an affidavit that has been presented before court and a determination made. There is no formal application for review before you and an affidavit in support of the facts that were placed before you. If the prosecution is making an application for review, they ought to have filed a fresh affidavit. Their arguments based on this affidavit are issues to be conversed in an appeal in the High Court. This court already considered this affidavit and made its ruling. And it is therefore functions official in as far as this affidavit is concerned. We acknowledge the matter has elicited a lot of public interest, but the procedure of the law has to be followed. And the procedures lead to a fair trial. So where they are flouted, this right of the accused person is essentially taken away. Your Honor, the last time we were before this court, the IO addressed the court and said that they need only 3 days to download, 3 hours, about 3 hours, to download information from the phone of the suspect. The Department of Homicide was with the accused person yesterday, the 9th of September, and we were...
Just a minute.
The Department of Homicide Investigations were with the accused person yesterday at Homa Bay Police Station, the 9th of September. And the suspect was interrogated from 10 a.m. I was in that meeting, Mr. Abisai and Mr. Amolo, and we left the station at 9 p.m. after.
How long did he stay with the investigators? The investigation, he himself?
He himself?
Yes.
When, yesterday?
Yeah.
Yeah, we were there from 10 to 9 p.m. with him and the investigators when he was writing the statement. We were there. So our submission, Your Honor, is that the investigations that are yet to be conducted are on other persons and not the accused or the suspect for that matter. What we are hearing from the prosecution is that they still do not have evidence at all to determine whether
Your time is up.
to charge the accused person.
Your final sentence? Your time is up.
What am I saying? Your Honor, therefore, if they still don't have sufficient evidence to charge the accused person, we pray that he be released on bail pending a charge as provided under Article 49 of the Constitution. 49 days. That is all.
Your Honor, the request for review by the state is an invitation that you,
The name again is Mr. Your name.
I'm on. The application by the state for review and matters connected there is an invitation to you, Your Honor, to derogate upon the Constitution. I say so because he wants to draw your office, that of the judiciary, into matters that concern.
Right, as you can see on your screen, those are live pictures from Homa Bay Law Court, where Michael Oyamo, who has been accused, who is appearing in court in connection with the death of Sharon Otieno. We can see his lawyers there just showing displeasure with how the prosecution has been handling that case when it came to collection of the DNA and also analyzing phone data of Michael Oyamo. And of course, just to remind you that the prosecution wants the court to have Oyamo still detained in prison for at least 10 more days, saying that they're still analyzing DNA samples and also the phone data of Oyamo. All that is still happening at Homa Bay Law Courts, and of course our reporter Kevin Ogutu is still keeping a keen eye on that live transmission. I need to pave way for my colleague Nick Wambua, who is up next to Leo Mashinani. Thank you so much for your feedback, but because of time, I shall be able to sample your feedback that we had asked you this morning on our Twitter poll question on what you think is the leading cause of suicide in Kenya. I'll now leave you with the live pictures of what is happening at Homa Bay Law Courts when it comes to the probe of the death of Sharon Otieno. My name is Brenda Zedaradid, and thanks to everyone who has made the KTN News Center a success, including you, our viewers. Continue enjoying the rest of your viewing, and of course keep it KTN News.
But before you is an application filed specifically in the Chief Magistrate Court at Homa Bay. Why did they not prefer this application before the High Court, which has the jurisdiction to try complaints of murder? If that alone is not an indication of abusing and desecrating our Constitution, what else can it be? I want to submit, Your Honor, that Michael Juma Oyamo is not properly before you. And Your Honor should not entertain the request being made by the state, because there are issues of jurisdiction which arise from the affidavit and from the remarks that the state has made to you today and made to you the first time this matter came up on the 5th of September. Let us not forget, Your Honor, that this court, the office of the DPP, are creatures. So So they must be guided by that constitution. They must walk the path that has been determined by that constitution. And that path, Your Honor, does not say or suggest or encourage a situation where a citizen of this republic, Michael Juma Oyoma, is being held at the pleasure of the office of the DCI so that they can conduct their investigations. When they arrested him, they had information that made them arrest him and keep him in custody from the 4th of September. It is now 10th of September. He has not been charged. A requirement by the Constitution that must be done within 24 hours. Michael Juma Oyoma does not know why he's being held in custody. It is said it is for murder of Sharon Otieno. It is said it is for kidnapping and abducting. I have no doubt, Your Honor, that once a charge or information is brought against our client, the subject of the proceedings, both the office of the DCI and the office of the ODPP will have weeks to complete their investigations and present the trial to court by calling evidence. But what they want to do is to hold our client in custody, doing absolutely nothing, because right now there is nothing that they have done from the time they were given this order. The only thing they have done, Your Honor, is to unlawfully compel Michael Juma Oyoma to give samples for DNA profiling. That's the only thing they've done. They have gone further, Your Honor, to refuse to accept and obey a lawful order made by you that Michael Juma Oyoma should not be removed from Mombasa police station and unlawfully removed to a Ugis and detain him there for a whole day. And by the way of taking DNA samples to provide. Your Honor, I am aware that you are familiar with the provisions of Article 49, sub-article F, G, and H of the Constitution. But just for the completeness of my submission, so I can feel that I've been able to do justice to my client's case.
Article 49?
49, paragraph 49, sub-article 1, paragraph F, G, and H. It says on the first, I'm looking at G, at the first court appearance, to be charged or informed of the reason for the detention continuing or to be released. So far, no charge has been brought, no information has been filed. When you go to G, to be released on bond or bail, on reasonable conditions, pending a charge or trial, unless there are compelling reasons. One compelling reason to keep Michael Juma Oyoma in custody. And here we are sitting, Your Honor, continuing to derogate and refuse to obey our Constitution. When you look at Article 2 of that Constitution, Your Honor, it proclaims that it is the supreme law of the Republic and binds all persons and all state organs at both levels of government. This court, Your Honor, is a state organ.
Mr. Mola, 2 minutes, please.
Yes, Your Honor. I'm just about to wind up. Article 3, Your Honor, enjoins every person in this republic to respect, uphold, and defend this Constitution. That, Your Honor, includes this office, this court. I am very uncomfortable that this court is being asked to continue keeping my client in custody. Yet, it may not have the jurisdiction to make that. The only order, Your Honor, that this court commands itself to make is to reject the application by the state and restore the liberty of the subject, Michael Juma Oyoma. I rest you.
Mr. Bissoy?
Yes, Fiona, I fully agree with my two learned colleagues and their submissions. Fiona only wish to add that we were before you on the 5th of September 2018. And order number 1, which Your Honor gave, was to the effect that the state is granted 3 working days, being 5th, 6th, 7th September 2018, to conduct investigations and draw up charges, if any. So, Your Honor, what we were ready for today as the defense on behalf of the suspect was if charges have been drawn. Nowhere in this order was it stated that this Honorable Court was to revisit the application. Your Honor, this Honorable Court cannot sit on an appeal on its own orders. But instead, what Your Honor is being treated to is a fresh application on an application that has already been argued and a ruling rendered. You know, that is not law. There is no single affidavit filed before this honorable court to state why this application is being revisited. Beyond on that particular day, I remember you having asked the then investigating officer, Mr. Hassan, who is here in court, as to the time he requires to finalize and bring the charges. And he said 3 hours. He's here in court. He said 3 hours. You know, we don't know what transpired between then and now that the prosecution now wants 10 days. Your Honor, what has downloading of phone messages, call logs to do with the custody of the accused person? Nothing. They don't need him to download all those things they want to. They don't need him to process the DNA results which they have illegally taken from the suspect. Your Honor, what the prosecution is doing, they are merely dragging Your Honor into their investigation. They want you to be part of it. By granting them more time so that they can continue abusing the suspect's rights. And we plead with Your Honor not to take their invitation.
You have 2 minutes, Mr. Busai. 2 minutes.
That's your time. Your Honor, the suspect remains innocent until proven guilty. There is no amount of theorizing on how this case is a case of great public interest that should allow him on his rights. For the state to be saying is that they have nothing so far against the suspect. And if that be the case, let the accused be released on whichever terms this honorable court may deem fit. And the case, then let the case go a proper court for its trial. We rest our submissions.
Mr. Imbali, in response.
Yes, Your Honor, let me try to respond to all the issues raised. Let me start by saying this. As senior counsel said, the right to liberty of the suspect is at stake. Your Honor, what about the right to life of the deceased? Our submission is, let's not try to rank provisions of the Constitution because they are enshrined in the same document. Your Honor, if I look at the order that you gave, and that is order number 1, I beg to read, it clearly says the state is granted 3 working days, being today 5th, 6th, 7th September 2018, to conduct investigations. So in the first instance, and I believe that was in your own wisdom.
Just hold. I think we need to refer to what I wrote.
Yes, sure.
The sentence stops at
Yes.
the state shall also benefit shall also benefit from the weekend to complete what will be left what will be left of their investigations, and thus the state is benefiting 5 days to complete investigations and draw up charges if any.
Fair enough, Your Honor. My point is you gave directives for prosecution to conduct investigations into this matter. And as my learned senior, Councillor Shoya, is trying to insinuate, this process is being conducted with the highest, take it from me, highest integrity possible. And that is why the specialized team of homicide has been brought to the ground to beef up support for investigators who are here. Your Honor, we have, in the process of being lawyers, they have also become experts. And they are talking about the process of DNA not being proper and stuff like that. Our submission is this. During the 3 days that the court gave us, we tried, or rather investigators tried as much as possible to do what they could. And within those 3 days, amongst other things that they did, they collected DNA from the accused person, which is lawful, after conducting a post-mortem of the late Sharon. Your Honor, we were working with timelines. As I said, counsel again said, the accused person or the suspect hearing is not being subjected to fair trial. What is fairness? Fairness means the accused person being given bond, the accused person being released from lawful custody. That is not the point. We are saying all these people who are in this courtroom, including ourselves, we want to see justice. And as much as they advocate for fairness.
Your Honor, in the course of Mr. Imbali making response, which is Article 2, he cannot go into facts. He addressed the facts, he is assured that to the facts, we have addressed the law. The only area that he can address you on is the matter of law. Whether the taking of DNA samples is lawful or not, that will be another day during the trial. It adds no value whatsoever to this proceedings.
Mr. Imbali, proceed.
Thank you very much. Your Honor, the same constitution that they are relying upon to put their own citation, Article 25 of the Constitution, I read, despite any other...
Mr. Imbali, a minute.
Yes.
You have 1 minute to go.
There are several other issues that have been five pending.
You have 2 minutes.
5.
You have 2 minutes. You have wasted 5 seconds of your 2 minutes. Proceed.
Looking at Article 25 that they are quoting, sub-Article A, despite any other provision of the Constitution, the following right and fundamental freedom from torture and cruel.
Your Honor, I wish to object to that line of argument. I addressed the code specifically on Article 25C. In reply, we cannot talk of Article 25A. I do not have a right to reply.
He is entitled. He's entitled. He's entitled. Proceed.
Your Honor, my point is, learned counsel are reading the Constitution selectively.
You are on the proper
My
line.
point
Proceed.
is, in the same article,
25A.
yes, freedom from torture, cruel, inhuman, degrading treatment. Your Honor, this case is one of the worst cases where a person can be subjected to torture, cruelty, degrading behavior, and what have you. So our point.
Na mtazamaji, kesi ya mauaji yake Sharon Otieno, mwanafunzi katika chuo kikuu cha Rongo, inaendelea katika mahakama ya Homa Bay, ambapo tayari Michael Oyamo ambaye ni mbeba mikoba ya gavana Okodhobado wa kaunti ya Migori amefikishwa kusomewa mashtaka. Hebu mtazamaji, mwanahabari wetu ambaye ni Kevin Ogutu yuko pale anazidi kufuatilia hiyo taarifa. Atakuwa anatupa mengi zaidi kuhusiana na hatua ambazo zinapigwa na mahakama katika kutafuta sababu na kini cha kifo chake huyu Sharon Otieno. Mtazamaji, vile basi kando na hilo ni kuwa Wakenya wanasubiri Rais Uhuru Kenyatta kuweza kutia sahihi ule mswada wa ushuru wa thamani ya ziada ya VAT, mtazamaji, kwa lugha ya Kimombo. Kwa hivyo ni matumaini tu ya Wakenya kwamba hili swala la ushuru basi litaweza kutatuliwa. Ni haya na mengine mengi ambayo tumekuandalia siku ya leo, mtazamaji, ikiwa ni tarehe 10 mwezi Septemba mwaka 2018 kutoka jiji kuu la Kenya, Nairobi. Hiki ni kipindi Leo Mashinani. Kwanza kabisa tupate tuliokuandalia. Mkono wa sheria waanza kuchukua mkondo kwenye mauaji ya mwanafunzi Sharon Otieno wa chuo kikuu cha Rongo. Washukiwa baadhi wafikishwa mahakamani Homa Bay hii leo.
Tusingoje kila wakati watu wanakuja kufuata muungano wetu wa Mijikenda, lakini sio kwa faida ya Mijikenda bali kwa faida ya watu wengine.
Tamasha za jamii ya Mijikenda zaandaliwa katika uwanja wa Karisamaitha, kaunti ya Kilifi. Viongozi wakiapa kuzungumza kwa sauti moja kwenye siasa za eneo hilo. Huko Kajiado, ofisi wamekuwa kero kwa kuwala mifugo kila kukicha, na sasa shirika la wanyamapori KWS lapewa siku 7 kuwadhibiti. Ulimwengu unaadhimisha visa vya kujitia kitanzi. Hatusemi ujitoe uhai unapozongwa na fikra, bali tutajadili nyendo na mbinu za kujinasua kwenye dhiki hiyo.
Sasa umepotea uko na mafuta? Iko.
Na kwenye vijimambo utajua kwamba kupanda ushuru wa thamani ya ziada wa VAT kwenye mafuta kuna maanisha uzito wa gharama kwa mwananchi wa kawaida. Na mtazamaji, mimi niite Nicholas Somboa. Kwenye taarifa yetu kuu siku leo ni kuwa kesi ya mauaji ya Sharon Otieno aliyekuwa mwanafunzi katika chuo kikuu cha Rongo inaendelea katika mahakama ya Homa Bay, ambapo tayari Michael Oyamo ambaye ni mbeba mikoba wa gavana Okodhobado wa kaunti ya Migori amefikishwa kusomewa mashtaka. Hebu tulekee huko tupate jinsi kesi inavyoendelea.
Your Honor, I still insist because of time is up. Humbly, this is a matter of great public interest. Everybody wants to see justice done. We are then requesting to allow us to come before you, possibly on Monday, and within that time, there will be proper direction.
Mr. Mbadi, would you want to address me on the issue of disobedience of the court order?
Which is?
Was the suspect, he's not an accused, was the suspect removed to Oyugis on Friday?
The role of the DCIO is here, probably.
I want you to address me.
You give me some time?
Yes?
Your Honor.
Because there's an OB, don't make me to call for the OB.
Yes.
Let's be straight.
Yes.
Let us all walk in the light. Was the suspect removed or not?
Yes, he was.
And taken, what time was he removed and where was he taken?
6 a.m. and returned at 7 p.m. in the evening. And Your Honor, you may allow me.
He was taken from Homa Bay Police Station.
Yes.
Which day of the week was that? A Friday?
Friday, Your Honor.
And the court was sitting on that Friday?
Yes.
You agree he was returned at 7 p.m.?
Yes, we do.
How many minutes were the advocates granted to speak to him after he was returned? How many minutes were they allowed?
More than 1 hour.
More than 1 hour. You are aware that the court order stated explicitly that counsels were to have access on their client day and night?
Yes, ma'am.
Mr. Imbali, you agree that the state has already taken a statement from the suspect? Yesterday.
Yes, the person to that statement there more years.
How many hours did he stay with the investigators yesterday?
Very long, it's procedural.
I just asked the number of hours. I didn't say it was unprocedural.
From 10 a.m. to 6 p.m. together with the advocates.
Na basi hivyo ndivyo hali ilivyo pale katika mahakama ya Homa Bay ambapo bwana Michael Oyamo amefikishwa mbele ya mahakama, mtazamaji, kuweza kusomewa mashtaka siku leo kuhusiana na kifo chake Bi Sharon Otieno aliyekuwa mwanafunzi katika chuo kikuu cha Rongo na aliuawa, mtazamaji, na hivyo basi ndio wachunguzi wanazidi kufuatilia hii kesi ikiwa sasa inafika